Good afternoon. My name is Gage Whirley, and I'm a 3L at Tulane, and I'm the Senior Notes and Comments Editor for Tulane Maritime Law Journal. I'm here to present a brief overview of my comment entitled A Forgotten Agreement, a Comparative Analysis of Tramp Pooling Agreements in American Antitrust Law. I'm going to give you the conclusions of a market analysis I performed on both the tram trade and the liner trade, as well as a historical synopsis of how the law came to be as it is today. My comment begins with the basic observation that the tram trade and the liner trade are treated differently, specifically in regards to the cooperative arrangements they enter into, that being conference agreements with the liner trade and tramp shipping pools for the tramp trade. Under the Shipping Act of 1984, conference agreements are exempted from the Sherman Antitrust Act. Shipping pools, by contrast, are never mentioned, and this is because the Shipping Act of 1984 defines a conference as an association of ocean common carriers, and common carrier specifically excludes tramps. Thus, tramps cannot enter into conference agreements and have no avenue to antitrust exemption. To begin, the liner trade refers to vessels that sail on specific predestined routes and that they have a specific itinerary that they follow. The tramp trade, by definition, has no set schedule, and that they work job to job and port to port, and thus they can go anywhere in the world at any time, depending where the job calls them to go. Liner conference agreements are unique among cooperative arrangements because they are explicitly authorized to price fix. This is in contrast to other cooperative arrangements such as vessel sharing agreements and rate discussion agreements. A tramp shipping pool is a centralized administration, usually with integrated operations, where tramp vessel owners under a common pool manager operate as a single fleet. They allow for efficient chartering and optimization of space utilization, as well as increased marketability of the vessel owners and overall achieve economies of scale. In this way, tramp pooling agreements also make it easier to enter into the market. Looking to why Congress sought to exclude tramp pools, you end up with an international debate that began over a century ago. The first attempt to regulate the shipping industry was with the Shipping Act of 1916. At the time, regulators were faced with two reports. In America, there was the Alexander Report, and there was also the report from the Royal Commission on Shipping Rings in Great Britain. The international community had come eye to eye with what were then called price-fixing cartels, but who were outside the purview of municipal law. These conferences would engage in what is now called fighting ships. Fighting ships refers to the practice of sailing at the same time and on the same route as your competitors, and at a drastically reduced rate. And you could spread this loss among all members of the conference until eventually your competitor exhausted its resources and had to drop in competition. Conferences also gave deferred rebates in the form of circular agreements, whereby rebates were given to shippers as long as they used conference members over a specific period of time. In short, conferences are very good at restricting competition. And what arises from the 1916 Act is a judgment from Congress that shipping industry was unique and needed to be insulated from competition. Congress subsequently amended the 1916 Act in 1961, and then again getting the modern 1984 Shipping Act, which was also further amended through the Ocean Shipping Reform Act of 1998, which is interesting because it was the first time we saw a movement towards deregulation. So two interesting effects were that, number one, gave rise to independent service contracts, as well as in 1997, just before it was enacted, there were 32 conference agreements active in America. The following year, the Ocean Shipping Reform Act was enacted, and then by 2000 there were 22, and when you fast forward to 2015, there's only 3 such agreements. So the question arose why the tramp trade was largely omitted from this century-long public policy debate, and why the two could not enjoy the same exemption as the liner trade. Tramp pooling agreements didn't actually come into the spotlight per se until the EU decided to repeal its entire block exemption in 2007. There was a large study conducted to determine how tramp pooling agreements worked under the new regulation in the EU. And what they largely found is that they could very well violate the anti-competition laws if they were found to price fix. And there's an entire debate that I go into in my comment more about whether they do price fix. But the short version of the debate is that pooling agreements can either said to be price fixers or price takers. The price fixer argument is that the pool manager, because it has a larger market share as a representative of multiple vessels, can fix prices. The market taker argument is that they are still subject to the market forces, and that even though they operate as a cohesive fleet, they still have to outbid other market participants, and thus the charters are actually they are price takers from the charters. And in America, meanwhile, because they are horizontal agreements, they very well can violate antitrust law, but there's no specific case law that actually addresses how a Tramp shipping pool is addressed under American law. Some efforts were made, such as BEMCO, who made PoolCon A and PoolCon B in 2014, which helped to facilitate Tramp pooling agreements, but of course this is no guarantee that you're in compliance with the law. So the first question my comment seeks to address is whether the United States should have ever had this exemption, and I largely came to the conclusion of no. Many industries, such as railroads and airlines, at one point or time in the US history also enjoyed antitrust exemptions, and then largely since have been dialed back. Further, the Federal Maritime Commission conducted a study in 2012 after the EU had done its repeal of the block exemption, trying to see how this had affected the liner trade. What it found was that average freight rates were largely unchanged, and that surcharges and ancillary charges remained unchanged completely. And finally, following the Ocean Shipping Reforms Act deregulation, what I found in my market analysis of the liner trade was that it largely followed what you would expect of a budding industry right after massive deregulation. So while there is a market trend towards consolidation, with the top 3 companies comprising roughly 45% of the total market share, it doesn't seem to have negatively affected the liner trade, and it's, again, to be expected. Finally, there is no longer an argument to be made for international harmony. Under Japanese anti-monopoly law, as long as you fit being a ship operator, either a Tramp vessel or a liner vessel can engage in conferences. Under EU law, or regulation rather, neither conferences are completely unlawful. And then when it comes to America, liner vessels can engage in conference agreements, but Tramp vessels cannot. So the second question my comment sought to answer was whether the exemption should be extended to the Tramp trade. And what I largely there found was, again, no. The Tramp shipping market is actually generally regarded as a near-perfect competition model. It largely deals with low barriers to entry, it deals in homogeneous commodities, and is fairly transparent, completely derived from supply and demand. And currently there is no data supporting that a Tramp pooling agreement has ever or is capable of raising freight rates or restricting competition. So thus, I came to the conclusion that the exemption for liner conferences no longer makes sense under American law, but I also believe that the Tramp trade should be given finality vis-a-vis American antitrust law. Thank you.